Let's see. Pruitt there. She also needs a trial. Roche needs a trial. Let's finish up position 1. Attorney Farrell, while we wait for the other party, did you have a response to Ms. Johnson's request and the basis of your opposing her her request for continuance?
Yes, Your Honor. I mean, really, it's a very limited issue. She's here. We're all ready to go. But in terms of disqualification, I was representing landlord against her in a prior case. There was a confidential settlement agreement. I've not made any reference to that. So I don't know the basis of.
I object, Your Honor. He did subpoena medical records, an extensive history of records that go far beyond this case that could go into the other case, and that case is still can be revisited. And he was not privy to those same records in the last case. He did ask for discovery; those were not given. But he's used this case to subpoena my medical records, a historical amount, not just for what's going on here. And he's created a matter of controversy in order to do that by saying in his response that I could not have been in the ICU and had a visit with my primary care, which was a televisit, by the way. But he tried to say that, and then he subpoenaed her to give a history of all my medical records. That would go back to the 2024 agreement that he and I had.
Not true, Your Honor. She
That is
attached
true. There's a conflict.
Ma'am, let me speak, please. I'll let you speak. You attached medical documents to your motion for continuance. I have a right to subpoena. I've released everyone's subpoena. I don't have any of your medical records. I don't have any of your witnesses. So
I just got that subpoena today. That subpoena was given to me at 9:45 this morning. I was unaware that he would go that far. I did try to present this conflict. I did try to present this conflict in a motion.
Folks. Well, let me just, can I ask you for really, why do you need the continuance? Let's start there.
The reason I need the continuance is because there was first of all, I just got out the hospital, but in the motion, there was in the agreement, the original agreement, there was $1,000 to assist with move out costs. It was not for them to move me out. It was so that I can get help moving out because I can't go back into that building. You just asked me, you said, how could you get help to move out? I said I couldn't do that myself under those conditions because it's uninhabitable. As soon as you walk in, you're overwhelmed with the smell. Somebody said they would charge me that amount. So I said, okay, but they would not release that to me unless I signed a contingency agreement releasing them of all future claims and all this other stuff and tons of all this stuff. And that was not what we agreed to. And that's what I'm trying to get to. But it's hard for me to vocalize that under stress, is that is not what we were getting to. They delayed giving that to me. They said, the only way you'll get that, and they wrote it in this is not what we went over in court, is if you sign this. And he tried to get me to sign a 5-page document that said, you won't do this, and you won't do that, and you will never do this, and you will never do that, and you won't hold any of us responsible, and all these other people. And that was not part of the agreement. It was a simple agreement that really sucks. Claims.
I mean,
So now the continuance is because I haven't been able to get that amount. I do have personal items in there, even though I'm not in there, that I don't want not given back. And the reason that we decided that they would give it to me and not me pick it up is because it wasn't as easy for me to do as pick it up. If I could pick it up, I would have done it in the first place. But because I can't go in there to get those items.
Okay, so Ms. Holden.
So I need more time for that.
Well, I don't know if you need more time because
they haven't released.
I understand. So just listen to me. Yes. I'm hearing what you're saying, and I'm going back to the order, and then I'm going to ask Attorney Farrell. So obviously, Attorney Farrell, you got to sign a mutual release, right? Now, obviously, because you didn't have the release provided, she's disputing the release that you provided. It's not mutual if you guys don't come to an agreement. But basically the mutual release will not cover damage if done to the property, defendant, or any occupants. That's fine. So any future damage is not going to cover. And defendant Kiana Johnson has signed the mutual release, which will be in exchange for the release, you'll get $1,000 of your security deposit. Now that's what it said on the agreement and proposed order.
That's not what said in court. Yes.
Okay, you're saying the mutual release, the $1,000 is to be paid. I assume not before the mutual release is signed, because that wouldn't make sense just to give you the money before the release, or if giving you the release, giving you the money in anticipation, knowing that you would sign the release.
What they agreed to, Your Honor, was that I would get the $1,000 within 7 days of when we left court, so that I could begin moving. That's what they agreed to. And they said it was in lieu of the security deposit. So they weren't going to be under the same statutory requirements as the security deposit, which means that they're all also asking that it be returned to condition of normal wear and beyond normal wear and tear. But that goes with statutory security deposit requirements. There can't be normal wear and tear because there's already water damage. They haven't included that. They're going to try to tell me that I did the.
I don't know what they were going to try to tell you, because obviously you guys would have a mutual release.
But we did not. It said in lieu of the security deposit, and
I get that.
Yes.
So, Attorney Farrell, your response.
Your Honor, we did have a little bit of a kind of a normal standard release, and then we basically reduced it to one sentence. I hereby release all of claims unconditionally against the landlord, and if you sign that, we'll give you $1,000. That's how simple there was a negotiation, and we basically catered to her and to what she wanted.
Object, Your Honor, that is untrue. I've not received anything with one sentence.
Just you can object, but folks, first off, what I don't like people is when you just object and don't file a basis. Then it's a no point. I don't know what you're making me think of whatever you claim is the basis of it. I could think of 1,000 reasons for you to object. But that's not my job. And I'm not just telling you that, Ms. Johnson. You Attorney Farrell as well. You guys are just yelling out object. Object what?
I'm sorry, Your Honor. I was never presented with a one-page release.
So
that is a one-line release. That's not true.
So this is the issue. The issue is she's saying she can't move because you didn't supply the release that was essentially agreeable, which then you're not going to give her the $1,000. She can't get the $1,000. She's saying that impedes her ability to get. Now, that wasn't agreed to, that you were going to take this $1,000 to be able to get people to move. I understand that was your intent, but that
was the agreement. We literally said that.
So
we
you guys don't. I understand, but most of what you're saying is about verbal agreements that were not rendered into an order. But the judge repeated that agreement verbally in court, and then Attorney Farrell, outside of the court, drafted up an order with what he wanted instead of what was agreed to and what was repeated. I understand. So really the only issue though is your release and the $1,000. They want a writ, right? I don't think I have a problem with the writ because
Your Honor, the writ was also not part
over
of
me. That's your problem. You cannot get ahead by talking over people.
That's a disability.
Well, no, it's not. It's foolishness. It's not a disability. No, it's foolishness. Okay. Again, I haven't read anything about your disability, your cognitive disability. You told me that you have an issue with asthma and other allergic reactions.
They were exacerbated. I've had a cognitive issue.
But you're not in there anymore.
So
okay. So then you might need an attorney. Can you truly say that you could enter into any of these agreements voluntarily based upon your condition? Or is it just based upon how you are stressed depending upon the current situation? I'm just trying to make sure like what you're arguing, because 1 minute you're saying you don't have the capacity. And another minute.
Your Honor, if you give me a minute, I can explain. So my neuropsychologist who treats me for my TBI injuries, my history, basically he sent a letter to the other county that have accommodated me.
All right. First of all, this judge reminds me of Aziz Ansari in the biggest way. And second of all, I got a couple of things I need.
Any objection? All objections.
That for sure.
Anxiety leads to constipation.
Because I feel an IBS rant coming on. Let's get back to it.
Because I'm
just going to let you.
You're not. No.
Minute.
My time and our time.
Okay, I was trying to explain my disability. You said my capacity. It's under stressful situations. Under stressful situations.
What's so interesting?
Do I become verbally overwhelmed?
Respectfully, a litigation is what you've entered into. That's a naturally stressful situation, right? You then ask for accommodate. You can't accommodate stress. There's no way to just listen to me. There's no way to accommodate for the stress of litigation. There just isn't, other than having a representative. You don't have a representative.
I've asked for one.
There are no public defenders for this type of matter unless you go out and get one. You're not talking, and so unless you go get a designated representative, somebody that could do that. You've had the opportunity to do that. You've entered agreements by yourself.
Okay, I got this recently. It has so many applications. It's just I can really play it pretty much every hearing.
She just needs an Italian sausage and a corn dog, and that would fix her right up.
So I'm just want to make note of that on the record of what you've done thus far, and now what you're bringing to the court's attention, as well also arguing for yourself. You're literally, at least to the court, you're picking and choosing when you want to necessarily allege. That's just what it looks like. So I just respectfully, I just want to understand Attorney Farrell. You guys haven't been able to reach a mutual agreement for the $1,000. How do you plan on resolving that?
Judge, we have the $1,000 ready for her today. It's a one sentence, a release that she'd have to sign.
And Ms. Johnson, what's your response to that?
Your Honor, what do I do with the $1,000 if I have till 5 o'clock and you've had me in court till 2? Do you understand? And just to get back to on the record, what we discussed about my disability is that I have had reasonable accommodations in another court, in another county. And there are reasonable accommodations where I can speak for myself with those accommodations in place. And that is under Title II of the ADA Act. And so courts are supposed to give reasonable accommodations, or at least say why they're not going to allow that.
But you're not telling me what you really need.
I did. I sent a motion.
No, tell me. I understand, but you're in an oral motion hearing right now.
I've
Tell me
already
specific. No, don't tell me
first.
what you've already. Just tell me now. Why is that so difficult?
So that would mean breaks. That would mean a support person. That would mean note taking. That would mean I could answer more than just yes or no. That would mean there's a list of things. Right now, this is a stressful time for me to go over that list. I haven't been given those accommodations, and I didn't just pick and choose. I asked for those accommodations prior to the first hearing ever. I asked for those accommodations. I didn't just pick and choose. I entered into the first hearing I entered into the first hearing letting you know that my condition was exacerbated. Not that I didn't have this pre-existing condition, but it was exacerbated and that I needed those accommodations. So I didn't pick and choose. And I don't pick and choose when my disability would become an issue either. But I
just don't recall. Just be honest with me, and I'll be honest with you.
That is honesty.
When we entered into this agreement on the 2nd, honestly, when I was in a hospital bed, when I got you under oath, and you,
I love this. I love this because it's honest. The judge is like, he isn't trying to be rude, but basically saying, listen, honey, you're not that interesting. I've got a bunch of crazy people. You're just, I mean, you all blend together after a while. Get over yourself. We'll get through this. Okay.
Under oath. I came in late. I never raised my hand.
I don't enter into these agreements without having people go under oath. But if
Your
you're saying
if
you were never, I can check my record.
Check your records. I never went under oath. Attorney Farrell, would you like to agree to that? I never went under oath.
Attorney Farrell, does she place?
I don't remember, Your Honor.
Okay, I thought you were shaking your head.
No one remembers, but I did enter late from my hospital bed. Are you correct? I never did this.
Ms. Johnson, I think what you misunderstand is that what we have is a consent agreement that when you say that we spoke and we talked, so I know we spoke. I know we talked about the terms and I put everybody under oath.
And those were not the terms on the agreement.
Stop talking over me. My God.
Sorry.
What is wrong with you? I know what's wrong with you, but
disability.
Okay. Well, I'm not going to hold your disability against you, but what I will find is that you're entitled to the $1,000, but you've got to sign the release. Now, if you don't want to sign the release, then you're not entitled to the $1,000. I'll be frank. Stop talking over me because I'm not going to say it again. Now, if I'm going to look at this objectively, the truth is that the writ of possession could still be issued despite the fact of the $1,000 not being issued. Now, that just means that you don't release their claims and you can pursue them independently for whatever claim that you so choose. The $1,000 that I see here doesn't specifically indicate that your $1,000 was specifically used to have somebody go in and remove and retrieve your possessions. That's not what it says, nor do I recall that was ever being the basis. If that's what you're saying, that was the communication and the hopes that you would accomplish, I understand that. But that obviously didn't happen. And just because the parties don't reach an agreement on the mutual release doesn't indicate that you weren't necessarily agreeing to vacate by the 30th. Now, if you guys want to appeal that and essentially address that issue, that's totally fine. But what I cannot get over, Ms. Johnson, is that there was a consent order that has been signed by the court, that you're not disputing necessarily the terms, other than the fact that not the terms of the consent order, you're disputing the terms of the mutual release.
Your Honor, I'm disputing more than that, because there was not supposed to be any type of beyond normal wear and tear. That's on the consent agreement as well, because there are issues already in the home past normal wear and tear. There was a whole water damage issue.
So then that just means, again, you guys need to address the release. The release is the issue, not the writ of possession. The longer you stay out of, and this is the part that is of difficulty, the longer you essentially contend to have possession of the property, there's still damages done to them. I understand that you're saying that you have damage by virtue of not getting the property, but this is an ongoing situation. So every day that it is continued, the damages for them increase. That is the weird nature of the landlord-tenant matter. I'm unfamiliar with your counterclaims, if any, that have been addressed. And if anything, they would have been based on this agreement, essentially been released, right? And so all I'm saying to you is that if you want to rehash the case and you're trying to overtake, I don't have enough to say that the consent order agreement should not be honored. I don't have enough, not based upon what I've seen today. But what I do have is, I do see that a prong of the consent agreement has not been fulfilled because the parties have not been able to reach agreement on the mutual release, because that's the prong that seems to be as of issue. And so, Attorney Farrell, you're saying you're going to give them the money. I haven't seen the release. I'm not your attorney. Since you don't have an attorney, since you didn't go out and somebody isn't there for you to speak for you, I don't know. I only have you. So based upon, you're saying that someone was supposed to be supplied, and if there's an attorney that was supposed to be supplied, I don't know.
No, Your Honor, weeks ago, the agreement was a time frame where we left that hearing. I was supposed to get that money and be able to move out with that money. The reason
I just
that I
can't
didn't get
imagine
it
you would get the money without the release. They're not.
But the reason that it did not get signed, one of the reasons that we are here today is because Attorney Farrell decided to draft a release that had nothing to do with what we agreed upon or what you said we agreed upon. It had nothing to do with that. He added extra language, and that extra language was not what we agreed upon. And so to make me have to sign a release that we didn't agree upon in court, and he's saying that now it's a one-line release, but I've never seen that. He doesn't state what that line is to you so that we can confirm what that is. And here we are, September 30th, and most of my day
Ms. Johnson, I cannot be your lawyer, respectfully.
I'm not.
I know, but in many ways, what you're essentially arguing with the court to do, you're asking for, listen, this is the part, this is the problem that I don't understand. Continuing the case for what? For him to get a release that you may or may not accept. I don't have authority to demand.
No, Your Honor, the reason for the continuance, I put in my motion the reason for the continuance. You have not addressed that reason at all.
Which is
the fact that I just got out of the ICU. My condition has been exacerbated. This release, and I'm adding to this, is that the fact that I only asked for time to be able to, I'm asking you now, currently, for time, and it doesn't matter if it's a week, it doesn't matter if it's 7 more days, just time to be able to, if they do agree, if we do get that $1,000, if we do move forward, that I have time to have someone at least come in and get those things. That's it. I am not in the property because it's uninhabitable. My counterclaim is not even in this jurisdiction. It's over $15,000. I've already spent a higher amount just staying in hotels.
So Attorney Farrell, what is your position on the issue of the release not being yet not being agreed to, and the $1,000? Because I mean, I understand you can't force her to sign, and Ms. Johnson, you have to determine what you want to do, because if that's something that's not signed, then I'll be frank.
You want me to sign something that is fraud?
I can't tell you whether or not it's in your benefit.
I'm telling you.
Meaning she was bleeding out of her hoo-ha.
I have a simple solution, maybe. And my client is here, by the way, Your Honor. He's Mr. Thomas.
Yeah.
Yes, I'm here. I'm here, Your Honor.
Yes.
Well, Mr. Thomas, I haven't gotten you under oath, so let me just hear from Attorney Farrell.
Sure.
Well, Judge, we could just modify your order and just say the parties, I mean, it kind of says that anyway, but basically we could just make it simple that all I mean, the order read that the complaint was dismissed with prejudice and the counterclaims were dismissed with prejudice. So, and then everything left beyond September 30th was deemed abandoned, except that my client would notify her if there were things in the property that she may want. They definitely didn't agree to transport any items for her, but we could just basically, I could amend the agreement that'll have a language that says the parties release all claims against each other related to this particular property, except the condition of the property. You know, if the property is been damaged, my client doesn't know that. He hasn't been.
I object. That exception does not include the
Well,
fact that
folks,
there's already damage.
so this is the problem, Ms. Johnson. I can look at it in the sense that you guys have a consent order and one of the terms had not been addressed. And so we can leave that open. I think that that's still a way to address it, because possession becomes problematic, Ms. Johnson, just honestly, that if I allow you the case to continue on and there's no other agreement, you guys are not intending to take possession, that obviously has a continued harm on the defendant when it was the intent for you to be out by the 30th of today, at the end of the day. Obviously, you're saying all of that was based upon you getting money from, based on a release. Now, you don't want to sign the release because
It's not that I don't want to.
you don't want to sign the one that they presented to you. That's a fact. That's what you repeated over and over again.
Because those terms are not what we agreed to.
But there are no specific terms, and I understand.
There are. We gave a whole 5-page
But in the
list.
specific order, there is no specific terms that are laid out other than saying it'll be a mutual release. There was no actual release identified. This happens a lot. I'll be frank. This happens a lot in civil cases. People don't get paid for months because they can't agree on releases. So it happens. You're not entitled for it to happen quickly. That's a fact. And no, it is frustrating your goals, but that's the fact. So if you guys can't get that signed and redressed, obviously that would impact the remaining portion of the agreement because you don't have a full, everything has not been completed. And so Attorney Farrell, unless you guys can come up with something else, Ms. Johnson, it's hard for me to acknowledge that you'd have to get out and you leave all your stuff and you don't have the ability to get it, but it happens to a lot of people. So I'm not trying to be difficult to you, but a lot of people, not just listen to me. Just because you have ADA issues and accommodations doesn't give you the basis to, particularly when you don't have like a subsidized rent or anything justified that you be able to stay in the property or to be able to delay the process any further than what you have. And so,
may I, Your Honor?
Sure.
Okay, Your Honor. Your Honor, if the original argument, and we're not going to try to relitigate the case, but the original argument is that the property was uninhabitable. I couldn't stay there. When you originally started this case, when you originally came on, you said if there was a condition where it was uninhabitable, then that would be a reason not to pay rent. Also, rent was stopped. They agreed in July. They sent me.
Well, I'll be frank, Ms. Johnson, You're now relitigating facts. I'm not hearing any facts. We're hearing on a motion that basically based on a consent order. So this is what I'm going to do. Attorney Farrell, how do y'all plan on getting her the money? And I guess, again, you're not forced for her to sign just anything. I don't think, Ms. Johnson, you understand that a release has to be agreed to. And if you guys don't agree on the release, then the money isn't given. But then that means you retain all your rights. That's the harsh part, because I know for you, sometimes your rights don't seem as valuable as the $1,000 part.
When you say my rights, could you elaborate?
What I mean is you're saying that you're relinquishing, you're dismissing your claims. That was the part that seems like there's a problem, that you're dismissing all your claims.
But you're saying I don't if I don't sign the release.
Right. And I'm saying, but then you have the ability to not sign that portion. It doesn't mean that the writ doesn't get issued, but you don't have to sign that, and you don't have to take the money. And then you have all of your counterclaims and things that you would desire would potentially stay in play because you never signed the release.
Your Honor, one thing I wanted to ask, the agreement originally was there would be no writ. The September 30th was the last day of the lease. So there's no need for a writ. It's the last day of the lease.
Which if you haven't vacated, there would be a need for the writ.
Well,
Well, go ahead, Attorney Farrell. I'm sorry. Maybe I misstated.
No, I mean, the order states that anything left beyond the 30th would be deemed abandoned. Well, can I ask Ms. Johnson one question, Your Honor?
Sure.
All right. Ms. Johnson, if you got the $1,000, how quickly could you get your stuff out of the house?
I could try to get somebody to help me get it out within a week. Hopefully.
See, there's that hopefully.
I mean, but if I couldn't do it, let's just say 10 days. If I couldn't do it within 10 days, then we would continue with abandonment. But what we did agree upon, and I just want to revisit that, is the fact that the valuable items. So there are things in there like my father's ashes. My
Then
son's
go get
autism
'em.
stuff.
You can't get any of these things when you have these
I
folks
can't
come and
walk
get your
in,
stuff.
but I'm
No,
gonna
not
try.
you personally.
No, when
Listen
the
to
people
me.
come, if I had 10 days to do it, yes, that's what I would do. I would try to get the most out, and then everything else would be abandoned. That's all I'm saying. But it wasn't.
Also, the
what he-
balls in the
Attorney
fridge.
Farrell, let's stop.
Yes.
We don't need to hear anything else from you. Attorney Farrell, what's your position on that?
My Mr. Thomas is here, and he's
Mr. Thomas, you unmute and raise your right hand. Swear affirm to tell the truth under penalty and perjury of the law.
I do.
All right.
Your Honor, all I have to say is simply, you said it perfectly. We are hemorrhaging money because we're not getting paid rent, and not for just 1 month. But we said, don't pay us anything, just go. What landlord do you know? You've been doing this for a while.
As far as the black letter of the law, the release doesn't deem that it has to be signed before the walkthrough, but there does need to be a walkthrough, and there does need. So I take it you guys have not done the walkthrough.
He wouldn't let us.
Your Honor,
She
that's not.
wouldn't let us.
Your Honor.
I can't get my place, Your Honor.
Stop.
Your Honor, we repeated in court, and you asked. If you were the same judge that was in court, you asked Mr. Farrell. You said, "What is $1,000 on?" He said, "Is it because of the security deposit walk?" He was like, "No, it's just $1,000," and he just kept repeating what it was for. And you kept mentioning a walkthrough, and it was in lieu. He kept saying it's in lieu of the security deposit and the statutory requirements that come with it. He also wrote that in an email to me, and in an agreement, he tried to get me to mutual release. So that whole statutory requirement where there's a walkthrough and there's this, that, the other that comes with security deposit.
There's no statutory requirement per se that you have to have the walkthrough. There's statutory requirement that they have to send you notice of what the alleged damages are and what they're deducting. But yes. I guess again, you guys, it's not that you guys are wasting time. It's that ultimately what we have is we had agreement. A portion of it was not executed. And so now you're saying we want to blow it all up. I'm saying, I'm looking at the terms of the agreement that can be exercised because it doesn't seem as if there was a time period identified on the release. Now I know that cuts back. He
verbally stated it in court that it would come that it would be $1,000 given within 7 days is what he stated in court. And that was 7 days. I
don't recall. And
I was in the hospital, and there are witnesses that do recall.
But those witnesses, even if you do have witnesses there, the record would be the best thing.
The record.
If you don't want me to do the following, because there's a strong position that I can look at this thing and say, honestly, neither one of you have done what you're supposed to do. Now, if you're saying that she has blocked your ability to do the walkthrough, and you've not, and she just is not willing to, because if you, Ms. Johnson, you don't have you have the authority to not sign the release. I think that's the part that you're not getting. You don't have to sign the release. Signing the release only gets you $1,000. So that isn't necessarily essential to the terms of this agreement. That's if you only sign it. So everything else isn't necessary, isn't predicated on you signing this release. That's the part that I think I want you to understand. The release is totally separate. The walkthrough is its separate portion, as well as you vacating is a separate portion, right? So you need to be out by 9:30 at 5 p.m. That's not going to happen, more than likely. So that means they probably request a writ. Now, you were supposed to also do a walkthrough, right? And you'll dismiss all your counterclaims, and you will not own defending any of the counterclaims and attach damage beyond a normal wear and tear. Well, that was if you did.
Mutual.
Yeah, but that's if you guys were to do a walkthrough.
Liberty Mutual.
But you guys, I don't see the word Liberty Mutual, but I don't see that in here. The only thing I see is that, you'd vacate, and if you vacate, by that time, you're essentially releasing all your counterclaims, and then you'd sign a release by releasing all your counterclaims, and you get $1,000 from your security deposit.
And there's no record of the hearing.
Oh,
Judge,
good
just to be
Lord.
clear, though, the counterclaims are already
There's more?
dismissed. You've already signed an order, and the claims are dismissed, to be fair. So
Not-
that part's a fait accompli.
No, I object.
Y'all just be saying object. I almost don't want y'all to use the word, because if y'all not gonna have a basis behind object, don't say object. If you don't have a basis and don't lay a basis for the objection, just saying objection is just noise to me. So you give me a reason why you're objecting before you just say object. This isn't like a deposition, where you just but let me do this. I'm gonna let you take another break. I'm gonna send y'all to the breakout room. Maybe y'all can talk and figure it out, because I've got other cases to get to. And so it really is between y'all. If I make a decision, you're not going to like what I'm going to do, but I'll give you guys another opportunity to see if you guys can resolve amongst yourself.
Oh, no.
Your Honor, I appreciate that. Greatly appreciate it. But she has proven to me, if not this court, that she cannot be trusted.
Well, who knows?
There's no need to go forward.
Next time, listen,
Wow.
next time,
Landlord refused to make repairs.
be quiet. Next time, I'm just going to have everybody sign. And you can guys do it as an electronic document, and everybody will sign it. And counsel, you'll have all the documents done. We won't have to worry about another document being produced later. Because basically what you guys did is you guys went to a mediation, did a mediation, and now you guys are coming back saying, Judge, we haven't really reached an agreement. And that stuff happens all the time, Ms. Johnson. So that means you guys really don't have an agreement. That means we could have a trial. Now, that would be the way I could do it. I could say, you've got to consent. Neither party has consented to the terms and agreed. And then we can have a trial.
When would the trial begin if we did?
I guess instead of a continuance, I'd reset it for trial, because we haven't been able to address all the other matters in the consent agreement. Attorney Farrell, what's your position on that?
I would respectfully disagree, Your Honor, about that.
I would
It should
agree
be a trial.
I would agree with trial.
And Attorney Farrell, what's your basis as far as the parties not essentially performing all of the agreed terms in the consent agreement? What's your position on that?
I guess you could have a motion to enforce agreement. That would be, if Ms. Johnson can state, well, I'm willing to sign it, but you're not giving me the $1,000. That would be an option that she would have. I don't think we can blow up the whole thing though and say, go back to square one and have a trial.
No, I listen, I'm generally agreeing, but I'm trying to determine what terms are you saying that they didn't do, but it comes back on you, Ms. Johnson. I'll be frank, it really comes back in your plate. If they give you a release that you don't want to sign, then you don't have to sign it until you're comfortable. Or you can have somebody who's a lawyer that reviews it and says that you're comfortable, but you don't get to push back. You don't get to agree, but the problem then becomes you don't get to sit on the house too. You don't get to do both.
I understand that, but
so why don't you take a break and think about what you want to do, and I'll deal with other people's cases.
I just wanted to ask you a question before I do that. If we were to go to trial, because you mentioned,
I don't think we will. I just was a thought, but when I think about it time and time again, because this is producing, I'm trying to give you an order today because I really don't want to continue it. Is that I'll be frank, 9/30 is the date. Whether or not you sign the release and release all your claims is a decision of your own. I know you're saying that there's an order where there's dismissed, but there's not a mutual release. So I don't know exactly what counter thing. I mean, that's usually dismissed. I don't really know if I signed it with prejudice, but obviously claims that wouldn't be applicable here could still be arguably alleged at another time. So the money is only if you do the walkthrough and agree with everything.
More than just the money,
but I know it's more than just the money to you.
I mean,
but so why don't you pause? Because I have a strong feeling about what I want to do. But why don't you pause? Think about it. Attorney Green, what do you have?
The trial in position 3, it's a judgment on the pleadings.
You guys, let's do 6 first. Cinque.
Afternoon, Your Honor.
Attorney Ms. Roche.
I'm stressed, Your Honor.
No, everybody's stressed. But that's life. Nobody. I don't understand. That's life. Raise your right hand. God, I'm stressed. You swear or affirm to tell the truth under penalty and perjury of the law?
Yes, sir.
All right. Well, let's figure out. Maybe it's not as stressful as you think. So, Attorney Green, tell me, is this a written or oral lease between Ms. Roche and you?
Your Honor, this is a written lease that went month to month.
Oh, I'm sorry, not Green. Attorney Cinque is month to month. Okay, and what's the monthly rental amount?
It is $1,705 plus a $300 month-to-month fee.
Hold on, that's not my, well, I'm not month to month.
Okay, well, let me just hear, because I do see, I see a couple things. So how much did you say it was?
$1075, Your Honor, is the base, and then there's a $300 month-to-month fee.
Okay. How much is a late fee if applicable?
The late fee. I am not seeing one immediately on the ledger. It is it's a $100 late fee.
Okay, last time the tenant paid rent from any source?
So the last time payment was made in any form or fashion was on May 30th.
Now, I know I see that you guys are not asking for any past due rent, possession only, and only rent in the future at 1075.
Correct. Yes, Your Honor. We're just looking for possession today, not a money judgment.
Okay, all right. And then Ms. Roche, I'll ask you some questions now. I just want to confirm.
Yes, sir.
Do you have a written lease with these folks, with the View?
Yes, sir.
Okay, and how much is monthly rent?
1075. I wasn't aware of any month to month.
Well, let me ask,
whatsoever.
when did your lease expire? Or when does it expire?
My lease expires, I thought, in May, like the May coming up, like next year.
2026?
Yes.
And
No,
so,
2026.
okay, so you signed a new lease in May?
Yes.
Okay, all right. And just let me confirm, Attorney, so just want to ask him, Attorney Sinkway, is that the case? Is this lease through 2026 of May, or has it already expired? I see you giving me this month-to-month thing.
Your
And
Honor,
when
the
do
only
they
lease I
have
in my
record it
possession-
expired?
Hold on, Ms. Rush. I'm
Okay.
sorry.
The only lease in my possession and corroborated by the ledger is states that this lease expired on May 16th of this year, and I don't see a renewal.
Okay. And then Ms. Roche, to your knowledge, did you sign a renewal in May?
Yes, that's why they receive rent.
Well,
That's why I pay rent.
So just so you know, you can, some things automatically renew, some things don't, and they just become month to month. So it's very dependent upon, it depends, on what's going on. But if they've been collecting 1075 since May and have not indicated any additional amounts, then it's 1075. I'm not sure about the 300 unless they would have put you on prior notice and been collecting that. So Attorney Sinkway, I hear you, but you guys, if you haven't been demanding it and giving a prior not notice, then that's different. But I see that they say they haven't collected rent since May either. And you say you haven't paid since May?
Tried. That's why I said I was speaking to the attorney saying that I feel like this is fraudulent filing because they are saying non-payment of rent, which is not the case. When you file a dual filing, it's supposed to be on non-payment of rent or a lease violation. That's not grounds for this. I've paid my rent and keep trying to pay my rent. They're refusing rent because of something that should be a separate claim. They have and I submitted those documents to you. They are alleging that I broke a gate that was already broken. So they are refusing my rent on grounds of that, saying that, hey, if you don't give us your insurance policy to cover this gate, then we're not accepting your rent and you can't stay here anymore.
Okay. Well, that's so I guess that's the bigger question then, Attorney Sinkway. I understand if that's a matter of you guys refusing to take her money opposed to, because I guess, did you guys give her notice that you guys would not be renewing and therefore, she would be deemed month to month, either month to month, or you guys wouldn't accept any more rent?
And Your Honor, I imagine that the notice was sent out.
No.
But if I may.
Hold on, Ms. Roche.
Okay.
On this matter, the basis purely is non-payment. The last time rent was current was May 1st. On or about June 14th, so a month and a half later, give or take, a charge in the amount of $14,479.34 was added to the ledger for damage due to the front gate. And under Section 8, subsection B of the lease, this is accessible as additional rent. And then paragraph 5, Section D of the lease allows this rent to be collected as an antecedent debt preceding the subsequent month's rent.
And so, you guys are not asking for that here, so I found that'd be interesting. Obviously, I'm always interested in how you guys allege that she was responsible for a $14,000 repair, but I guess that's that's another thing. There's got to be a process for that. You guys can't just assess damages to people without any due. Maybe you can. Maybe you can. I see it's not on here, but is it that she didn't? So basically, what you're saying is rent came due, but because you guys threw a $14,000 charge, unless you pay the full amount, you guys aren't accepting anything less than that.
Essentially, yes, Your Honor, but the notice.
That's terrible. You know how that goes. That doesn't sound good.
And Your Honor, if I may, they did provide a little over 2 months before they sent a notice to vacate. So they worked with the tenant for 2 months. No insurance was provided. No payment was made, and the tenant was
payment was refused for rent.
Okay, well that's a sin. Well, counsel. So I mean, I'll be frank. I'd like to see some documentation regarding this, because it does always raise my antennas when there's past due rent, but there's no past. I mean, there's an allegation of non-payment saying you're only seeking possession, but then now you're telling me you guys have assessed actual additional charges. I would argue whether or not why couldn't she then dispute that amount? Because it sounds like you guys are going to go after her privately for that amount, but not in the judgment. And that becomes problematic, because if she did try to tender payment at that time, and you guys are alleging there's this additional damage, I understand the contract, but I wouldn't it not be within the grounds for her to be able to dispute whether or not that charge was valid? Or is that charge just because you guys say so? That's what it is.
That was based on the contractor's work to fix the gate, to the best of my knowledge. And we did afford a little over 2 extra months to work this out amicably before notice to vacate was sent on 8/22.
Okay, so you're saying you guys did your own internal thing to determine whether or not she was responsible, and as a result, you assessed that repair to her directly.
Yes, Your Honor. And insurance was asked for, but it wasn't provided by the tenant.
Well, I mean,
the gate has never worked, and the damage that were alleged to me is fraudulent.
Oh, okay. Well, I don't know. They're not asking for that amount here.
None of that has been given to me.
But the problem then becomes, counsel, you guys aren't asking for that in this judgment. I mean, in this complaint, right? You're just saying that you're not looking for any money. She's saying she could have supplied you the money, right? And then that's different, because your complaint is what your complaint is, despite the fact that there may be other things going on. It's kind of like the similar case. There's the consent agreement and there's everything else that's going around, right? Consent agreement, the complaint says possession only 1075. She's saying I've been trying to pay rent and y'all been rejecting rent.
Rejecting it.
So let me ask you this. What does the 3-day letter say?
The 3-day letter.
Didn't receive one.
Hold on.
Okay.
In material part, it reads that this 3-day notice hereby serves notice of a demand of a rent due, owing an outstanding unpaid rent and other charges in the amount of $19,336.34. The balance includes the following outstanding charges, and they do date back to May, which precedes the event with the gate. So there is unpaid rent dating all the way back to May.
That was paid on May 30th.
Well, not the 19,000, but you're saying.
Yeah, my rent. I asked them how they're just going to put charges on me for a gate that never has even worked. I sent you the email. I submitted the email to the portal that I sent to them, and I showed you their response. All they did was send an invoice of the whole entire gate.
Thank you, Andrew.
Saying I had to pay $14,000 something.
I'm just curious. Why did they think that you did it? Why did they think you broke the gate? I'm just curious.
I didn't. That's why I'm asking
why would
them
they?
to
There's a
prove
lot
it.
of people that live there. Why do they think that you broke the gate?
It was an incident with the box, not the gate.
Okay, what did you do with the box?
You said, what did I do with the box?
Incident with the box.
When I came in, my car kind of, I guess, hit the box. Somebody tried to run me off the road, and I hit the box, the actual box. But the gate itself, I never hit the gate.
Sometimes you hit the box.
Okay, but
you know the box, the little square box.
I get you, but that's the making. That might be the brain for the thing.
You said what, sir?
That might be the computer for the actual.
It was the
gate.
little plastic.
I don't know how much the repair might actually be. I mean, seems to be relevant. I mean,
But what they did was charge for the entire gate that has never worked the entire year plus that I've lived in this community. It's never worked.
I get that. And so the problem then becomes, counsel, this is the interesting part. You know, I know you guys are not demanding any, and so you don't have to ask for any past due money. You haven't paid rent. They're alleging that it's not that you couldn't pay rent. You couldn't pay rent plus the additional charges.
Correct.
Yeah.
When I went to the rent office
Now,
to give them my,
hold
okay.
on. So the counsel, really the issue is, I know she's not paid, but she couldn't pay the full amount because it's significantly more than what she would normally pay. You guys aren't asking for that here, then that makes it's material, but immaterial. You know what I mean? About her ability to pay. She's saying she could have paid all the rent, but for these damages, which she's disputing.
I still
So-
have the money orders for all my rent for all the
And
months.
she's got all the money orders for all the rent.
So, Your Honor, if that's the case, and I'm happy to hop into a breakout session, what we'd be more than happy to do in this incident then is
Because what I
Work out.
would like to do, because I'm gonna be honest with you, what you're saying that there was a breach on her part, right? Which then led to you guys assessing a charge, would then making all her payments otherwise not be applicable. But if for some reason she could dispute that and prove that it wasn't her fault, I know you weren't there, Attorney Sinkway, and you may have seen the files, but she's saying if she did damage it, ma'am, then you are on the hook.
I didn't. That's why I'm disputing
You
it.
just
And
said you hit it, but I don't know.
no,
I don't
not
know.
the gate.
I don't
Yeah.
know. But the gate has more than just one thing. It's the gate and the computer that controls the gate.
Right. But if you look at the invoice that I was seeing,
Okay,
it's for
so-
every
so-
component of the
I get
gate.
that. And that could be a basis of the dispute. Who knows? Maybe you could have paid some of it, not all of it. Maybe you should have submitted your insurance and maybe they could have disputed it. I don't know. And if that's a required term of the contract, then you could potentially be at breach for that portion as well. Because if you were required to have insurance to supply, the insurance very well could have dealt with that as well. But what I'm saying to you, counsel, is that I don't see that here. That's that's a condition or an issue that's not present. And so she's saying, I've got all the money, but you're saying it's still not going to be enough. But that's not what the complaint kind of says. You know what I mean? So do me a favor, talk to her real quick. Otherwise, you know, if you guys can do with something, and then I'll come back because I've got one other.
Your Honor, may
I
I?
got the other motion. Yes, ma'am.
I already told him the same thing that I told you. He said, hold on, let me call my client.
Well, let's
He called-
see.
He
There's more
called them
information.
and they
Ms.
said they
Roche.
want the $19,000.
Miss Roche.
Yes, sir.
Let's see what else they have to say.
Okay.
Because you don't know what I'm going to say. So
Okay,
it might
Your
be
Honor.
in your interest to just go ahead and see what they're going to say.
Okay. Thank you so much.
No worries.
So go back to the breakout room.
Mm-hmm.
Okay.
All right. And then Attorney Green, we got your trial. He's at position 3.
Yes, Judge.
Yes, guys. Let's see why we only had 12.
Judge, for position 3 in my case, we would only be seeking $2,487. That would be rent owed through the end of this month.
Okay. Well, hold on. Let's get
Charge-
Ms. Pruitt under oath so we can move along. Where is she? Did she leave? You guys are killing me.
She just needs
Well,
an
I'm going to
Italian
be
sausage and a corn
staunchly
dog,
and
and that would
vehemently
fix
opposed
it
to
right
this,
up.
this
I know.
case, Judge. She's
There she
been
goes. Ms.
on
Pruitt.
already.
She's right there. Ms. Pruitt, unmute for me. Raise your right hand for me, Ms. Pruitt. You swear or affirm to tell the truth under penalty and perjury of the law?
But wait, there's more.
All right. So, counsel, this is written oral lease.
It's a written lease, Judge, and if you look at the answer, I would move the court for a judgment on the pleadings.
Okay. I'm just asking you the basic questions so I know what's going on.
Oh,
You said
I'm
that a
sorry,
couple
I'm
times.
sorry.
Just tell me how much
No.
monthly rent is.
It's Judge, monthly rent on this is $900.
Is there a late fee?
Yes, there was pending late fees of $200 and
I mean, how much
utilities
are they?
of $100 and $18.
How much is the
The
late fee?
total owed through the $200.
Well, no, that can't be 200 a month because it's only
Hold
$900.
on.
So it's, I mean, at most it can be $90 at tops.
Thank you, Your Honor, because they've added a lot of.
Hold on, just stop.
Okay.
Judge, when the lawsuit was, it's $100 late fee.
Okay, so it's $90.
It's $100 late fee.
You know, we kept it at 10%, so it's
No,
not.
I'm sorry, but it would be 2 months. But it's 2 months of $90, and then it'd be $180.
Okay, so last time she paid rent was what month?
There was also, that would have been July.
Okay, so she owes for August and September, and if
July was the last time she paid rent.
Okay, so August and September, 2 months.
But there's also 108.
Yeah, a late fee
Yes.
of $118.
There's also 108. No, there's utilities of $118.50 per month. And then there's a $250 insufficient funds fee because her August payment was returned as not sufficient.
Okay. All right, so let me ask Ms. Pruitt. Ms. Pruitt, is your rent $900 a month?
Yes, Your Honor.
Is there a late fee?
Yes, Your Honor.
How much is the late fee?
It's $90.
Okay. Last time you paid rent in full?
It was sometime in July. I don't have the exact date.
Okay. Did you submit money in August that was subsequently returned?
No, I did not, Your Honor.
So you never submitted any payment in August?
No, I did not, Your Honor.
Counsel, just so I can clear, where do you get this $250 insufficient fund fee?
So that was a payment that was returned, Judge.
She's saying she never made a payment in August.
Did they provide a copy of what payment was made? Because I never made a payment.
Okay.
Then I think that this.
Well, I mean, it doesn't.
Have you had? Can I ask her? So can I ask her a question then?
Sure.
Okay, Ms. Pruitt, I will remind you, still under oath. Have you attempted? Did you ever attempt to make a payment that was returned as insufficient funds?
No, Mr. Green, I did not. I only had a verbal conversation with the property manager that I was behind and that I would try my best to pay as soon as possible. I never submitted any form of payment.
Okay.
And Your Honor, just because, like, that's just prime example.
So
it's fine. Testify happened.
Sure. So hopefully, you've got 2 months late fee. We got a year. Ms. Pruitt, anything that you'd like to let her know before we proceed?
Yes, I am currently actively and receiving that into write a letter to you all that was just received this morning. Other than that, Your Honor, he's not, he don't want to my money. Like, I've lived here for 5 years. Like, this is my first time in 3 years being behind on my payment. I'm just recently a new business owner. I'm trying to get the understanding of how my money has to flow for me to operate and have a proof of income.
Yeah.
And I have no issues with paying my money. I just have a lot of fees that on there that is not valid, that's making it hard for me to achieve my goals.
And I listen, I understand your frustration. However, I have to consider the fact that if you haven't paid rent in 2 months, they have authority to demand the full amount of rent that's owed and due. Now, as far as what I would say was owed, that would be $18.90 plus $18.50, which ultimately plus 7 days, which would be $22.18.50. Yeah. Now, I can't tell you what they're going to do after the fact, but that would be the amount that would be owed plus that would be and you till it's to vacate. Okay, so what I would tell you is that that's what we can do based upon the facts. Again, since the insufficient fund fee is not applicable based upon your testimony, then it'll be a writ on the 7th at 11:59 p.m. with that money judgment of $22,1850. And
So, Your Honor,
yes,
how,
ma'am.
if they're not accepting my money, if they don't want me my money and they just want me to leave, what am I supposed to do?
So that's the hard truth. They don't have to rent to you if they don't want to.
Get out.
And if you've missed a payment or breached the contract, they're not required to accept
Pretty
your money
simple.
after the fact.
Okay, Your Honor, which is completely understandable. But currently, we are under new management. And so it's like, do I have the opportunity to see what the new management is allowed?
You can always do that. People make agreements with folks all the time. I just can't guarantee that that's going to happen. You understand? It's possible, it happens. I just can't tell you that that's in fact is going to happen.
Yeah, because I'm just a little confused, which is exactly what I was explaining to Mr. Green, that I don't have an understanding of how this whole process works. But I've lived in my apartment for 5 years.
Yeah, that sucks for
I have
you.
every intent to stay and to pay my rent, but it's just like,
I understand. And I'm not telling you that what you're intending to do is wrong. It's just that if they don't want to rent to you because you've missed payments, then they don't have to.
okay.
All right. So I'm going to get you this order. You do have until the 7th, unless you guys agree to something differently, okay, outside of court, that you guys would need to submit something.
So who do I have to
Judge,
go
you're
to?
going
Can I
to
go
issue
through
that
my
order,
new?
correct?
I'm sorry. Attorney
Don't
Green,
have a-
I'm,
You're
yeah,
don't
gonna
have a
issue
choice.
that order.
Once you
Yes,
start the
I'm
You're
eviction
gonna issue
proceeding,
that
you
order.
can't
I
take
am
rent.
going to issue that order.
Okay,
So
thank you.
I know you need to go. I'll let you go, Ms. Pruitt. I'll let you go too. But again, that's going to be the 7th of 2025, 11:59 p.m. with a money judgment of $22,1850.
All right, thank you, Judge. I actually am gonna
So I have an
stay to
understanding.
watch.
What does that mean? I pay my money and I'm
No,
leaving.
it's a judgment. So it's
I
not,
have done it.
It's a money amount that's a monetary amount that's against you. If you pay it and they take the money and agree to let you to continue to stay, that's between you and the landlord.
Okay, and will I get that in writing?
You'll get the order, yes, in writing. Yes, ma'am.
Thank you, Judge.
Oh,
No
look,
worries.
we have contestant number 1 back.
All right, we can move along. And Attorney Farrell, did you guys have any announcement, or are we waiting on me?
It's like a real
You said I
stream.
could leave?
Yes, ma'am.
Okay, thank you.
Judge, I have a proposal. I know it's
Okay.
not what you asked me, but we're willing to give her the money tomorrow. I mean, it's because it's already 3 o'clock today. I don't think I can get it to her today, and we can deliver it to wherever she's at. And then we'll give her an extra 7 days from tomorrow. And then the court, we could put her in a court order and it could agreed upon by everyone in court today. Simple. Landlord releases all claims against the tenant, and the tenant releases all claims against the landlord pending walkthrough.
This is what I want you to do. Ms. Johnson, what do you have to say to that?
You said pending walkthrough. So if we get through the walkthrough and both parties disagree, then what?
Actually,
It could be
not a bad
you
thought.
may have put the place on fire, so they can't release. Well, they don't know what the condition of the property is right now, and you
So you
could start a
want me
fire there
to-
tonight. So pending walkthrough, that's Georgia law, where there is a claim that could be asserted against a tenant afterwards. That's kind of what Georgia law is. The security deposit statute contemplates.
So neither one of us would release claims until after the walkthrough.
No, that's not the way I said it. And
I think
my
that's why
client's
she's
willing to
pushing
release. You
back.
talked about water claims. They said
I
they'll
don't know,
release
but
the claims, including any water claims.
Wouldn't surprise me.
That's what you talked about in front of Judge Joshua Davis here a little while ago.
Yes, I'm sorry, Your Honor, if you're keeping up, is he changing things as we go? Because from what I understood, the first thing he said was it's simple, and then he continued to say other things after the fact. So I'm just trying to figure out what it is.
For sympathy.
Initially, you said it was just simple, and you had two sentences, and then when I repeat those, you make other.
It is
You make
simple to
other
people who
claims.
have brains.
And that's what the problem is here.
Ma'am, I'm
And
not
the
ma-
judge, I'm
ma'am,
asking Your Honor, did you
ma'am, let me
witness that?
talk. When you
Did you
ask me
witness
a
that, Your
question,
Honor?
all right, I'm sorry. I'm let the judge be the judge.
All right, so Ms. Johnson, he's offering that you would essentially have an additional 7 days for him to get you the money, and they would do the walkthrough in between that time. Now, if you guys for some reason don't do any of those things, then consequences to that consequences would agree. So what would the consequence be? I guess Ms. Johnson is clear. He wants more time and hopefully give you money for the release. Now, if you don't, I tell you before, you do not have to sign the release, but then you don't have to get the money either. So that's a fact. That is not something that's a fact. So you have to make the decision on what's more important to you, because the court, I'm not going to allow you to remain in the property permanently until you guys come up with an agreement. After a certain amount of time has passed, right, then I'm just going to issue a writ, right? Because ultimately the terms were that you were to vacate for various, for whatever reasons. So they're offering to give more time to get you this money. I can't tell you whether or not you're going to agree with everything, and I can't tell you agree with everything in the law. That's in the future. I can't tell you, and he can't agree to that either. Agreements in the future, to some degree, are illegal. Because you like say for it to ever occur, like saying dismiss claims that ever occur or maybe occur out of this particular claim, that might be more reasonable. But to say they ever occur, it wouldn't be applicable. That's not the kind of release that would be applicable. But
yes, that's right. That's what he wrote initially.
Well, and I don't know. I haven't seen it. So you telling me is of no value to me. So you guys can I would just, I don't know, suggest maybe you guys get her signature on it. Maybe that way you don't get to come back, Ms. Johnson, and say you didn't agree with whatever said. And Attorney Farrell, if you produce a release, I don't know how those terms would be made to make her feel comfortable, because I'll be frank, people send me releases, and if I don't like them, I don't sign them, but I don't get the money. So that, Ms. Johnson, what you're asking for, you can't have it both ways.
Now, Your Honor, I just want to put on the record that you are denying, just on the record, you deny my ADA accommodations. Is that correct?
I'm not denying. I looked at your accommodations, and pretty much all of them have been met, but for the having a person here, and you have not either identified who you'd want or what program that you'd get them through. So I would deny that, and I would say that that's not the case. Looking at your motion, you've had time, you've had breaks. This is over Zoom. You're not in a condition that I would argue would be more stressful than a position where you have a bunch of people around you. So I don't necessarily believe that the accommodations that you see in the base of how we've been moving have not been met. But
would there be a copy of the record?
You'd have to request it. But at
Can I
this
request
juncture,
it now?
well, I think you'd have to request it early, but you can
I'll
always
send you
make
a
that
link.
motion. You can make your
You didn't mention.
But Ms. Johnson,
as usual.
No. Listen.
You're not going to like the
I'm not going
comments.
to spend any more time.
My right to a trial.
So listen, one last time before I do what I'm going to do. He's made the offer to get you additional 7 days to get you this money, okay? And
May
to
I
be able to
speak
get your release. No, I'm going to speak, and then I'm going to make an order. I'm going to give you this last option. That's what he's saying. Do you want to do that or not?
I just want to ask a question about the option.
Yes or no?
I wanted to ask a question about the option.
You can address it to Attorney Farrell, not me.
Attorney Farrell. Okay, so in regards to the option, you said you would get the $1,000 to me by tomorrow. And then you said 7 days, and then we would do a walkthrough. I don't know how I'm going to do that going into that house the way it is, but a walkthrough. So that's another health risk. We would do a walkthrough, and based on what we see during the walkthrough is whether or not we release claims, future claims. Is that what you're saying?
What I originally said was, I was trying to make it very simple. You release all claims against the landlord releases all claims against you pending walkthrough. And then
so only the landlord gets an option to have an exception.
That's right. And the reason is because you have his property and you could be destroying the property. He doesn't have anything of yours. That's why it's different. You're not in the same position. And then in 7 days, during that 7 day, you get your money tomorrow. In those 7 days, you can get your people to come and take out of the property whatever you want, and then the landlord gets the property back.
And those are the conditions without an additional release.
The
fair.
the release is just what I said. You said
Just
it was
pull
too
the
complicated.
offer
I've made it
and
very
let the writ
simple. You
issue.
release all claims against the landlord releases all claims against
She's
you
disgusting.
pending walkthrough, and the landlord, and I'm adding more to it. I know you didn't like that last time, but it's for your benefit. That release also includes the water damage, because you said that before, that was something that the landlord could hold against you. And Mr. Thomas is here and he's saying he's not going to hold that against you.
That's right.
And that will be in the writing in the release.
Yes, ma'am.
That's overly
And I
generous.
could have
Okay.
it, we could make it part of the judge's order if you like, if the judge would agree to that. We could do it right. And you don't have to sign anything. It would be part of the judge's order.
And then the, okay, because I was just looking at my, how would we do the walkthrough if I could not go into the property without risking my health?
Here's another one that just needs the dart. Give her the dart and remove her. It's the only thing I can see is going to work here.
Zoom,
You could have a proxy, maybe
FaceTime.
a substitute,
your son.
or you could, I guess
Yep.
Mr. Thomas is offering to do a walk, he could do FaceTime or some kind of electronic ways you could do it.
And I just based on what the Judge Davis mentioned, we wouldn't enter an agreement. The agreement would be, it would not be based on future claims. It would be based on this right here, the current claims.
My position is you've already released the claims based on the dismissal with prejudice of your counterclaims. But having said that, so everyone has closure, you're releasing any other claims that you have, and then the landlord's releasing any other claims he has, and then the case is wrapped up, and hopefully you go about your life and you never interact with each other again.
Yeah, but those claims are contingent on current. We're not going into the future.
The condition of the
That means
property.
from today back, current.
I just want to say something real quick, and then I'll let Attorney Farrell talk. You voiced the concern in front of the judge here in the court and everyone that you didn't want a walkthrough, or you didn't feel like that was fair because you felt like we may try to come back and blame you for the water damages. As my attorney just said, we're willing to stay here in court and the judge can put it into the document. We're not trying to get you for the water damage. Everything excluding water damages or anything in reference to the water damages,
I like
totally
him.
absolved.
He's a pro.
I'm saying if we go in there and you, I don't know, did any other damage, who knows? Other damages to the properties that could exceed a lot of money. I think it's only fair that we do a walkthrough and have a look at the property. That's it. Just
I
fair.
get it.
That's
I
fair.
also think it would have been only fair that you would not let mold and anything build up, and you would have done the repairs in time.
Now we're
But you
rehashing.
chose not to.
Well, now we're rehashing. So do we have a deal going forward? Now we're rehashing.
I like Ken.
We're not rehashing.
Okay, well, that's our offer.
You chose to be a retaliatory landlord, not accept my rent. I was not late. You just didn't accept it. You decided there was no rent due. I sent that document.
Ms. Johnson, this is like yesterday's news, yesterday's weather. We're way past that. We're going forward.
Right.
So real simple. You said I sent you a 5-page agreement. Your point has been well taken. You've been heard. We're keeping it super simple. You release all claims against the landlord. Simple as that. Landlord releases all claims against you pending walkthrough.
That's right.
Release includes water damage. We'll get you $1,000 by tomorrow.
The
You
release
tell me
does
what-
not include future claims.
Ma'am, are you a whore?
No, it doesn't include future claims.
It does
But
not include.
you all
future
are not going to
claims.
have future. I mean,
I'm sorry. It
This
does
is what I'm
not
gonna do.
include future claims.
Listen. This is simple. I'm gonna grant your continuance for 7 days. If you guys don't work it out, there'll be an immediate writ of possession on that 7 days regardless. So you'll come back and see me on Tuesday, or you won't. When you come back on Tuesday, if you haven't done what you have done, then it'll be a writ, because possession of the premises has nothing to do with you collecting the remaining portion of the money.
I'm going to agree to his terms, Your Honor.
Okay, because that's what it's gonna be. So it's either that or that. But guess what? His terms don't matter until the order is signed by both of you. Whatever you guys got going on, when it got your signature on it and his signature on it. Otherwise,
you can have that today?
Be quiet to me.
Okay.
Be quiet. And then next week, you either will appear, right? or I'll see your order in my inbox for me to sign. And if I haven't signed it, you're going to come back to court. It's going to be virtual. So there won't be any issue for you there. And then we'll address whether or not you guys have gotten any money and signed anything. If you haven't, then I'm going to just give a writ because we granted your continuance for a writ of possession.
Okay.
And
so
then
no-
that'll be it. And you can disagree and you can do whatever you want to.
No, I'm not.
But that'll
just
be
wanted to know
the
about
order.
OCK
So I will
44,
see you guys
751.
next Tuesday. Hopefully you guys get it addressed.
OCGA 44-751.
Thank you.
Right to a
Thank you,
trial.
Your Honor. Thank you, Your Honor.
You're welcome. All right. You guys are free to go. Hopefully you guys can get everything in.
I object to
I would
OCGA
recommend, Attorney Farrell, if you guys have
447-51,
any
a right
new
to a
agreements that
trial.
are entered into, that they
I
have
have
her
a right to
signature
a
as
trial. I
well.
object
so
to
they won't
OCGA
be.
447-51.
All right, yeah. But that's what it'll
Statutory
be.
right to a trial.
Thank you.
Thank you, Your Honor. Have a good evening.
You're welcome.
Your Honor, we're excused, just to be clear.
Yeah, please. And again, like I said, if you guys do anything, make sure that it's signed by both parties. And I will see you guys both on next Tuesday anyway, just to confirm that everything's done so we can have full conclusion of the case. So Ms. Johnson, you would have gotten your continuance as agreed. But again, that continuance will not address the issues where you've already signed on a consent to be vacated by 9:30. We're just continuing it on because of the issue about the signing of the mutual release of $1,000, which I still don't think is relevant to possession at this juncture, based upon the reading of the consent. But based upon the totality of the statements made today and the offers that have been made by counsel, then we're ultimately going to see you guys on next Tuesday. But if no agreement is made, possession will be granted to them based upon everything else that's already in the record. All right? So
Okay,
I'll
Attorney-
see you guys next
Attorney Farrell,
Tuesday.
Thank you.
will
Thank you.
Yes, you reach out to me. Thank you.
Yes, ma'am.
See you.
Behavior in this case
All
is
right, Attorney
disgusting.
Hallelujah, we made it. We made it. She's getting out. Good job, Judge. You finally just said, look, you can take it's real simple. You can take a free $1,000 and leave in 7 days, or you can refuse $1,000 and get kicked out in 7 days. Yeah, I know you're not very bright, but figure that one out. Figure out which one of those two things is better. But in terms of leaving, you've lost. It's over. We'll give you a little time so you can put it together. But other than that, if not, then we're at that point, we don't care. And we will send the Fulton County Sheriff's Office out there and drag you and your stuff out on the street. That's how it works. Thank y'all for coming out. That was initially Alyssa sent that to me, but then of course in the background Brecken and Zach were helping me because I wasn't sure, because they switched streams on me, which is always a problem when you're pretty much live like that, because you don't want the stream going down midstream, so you don't get the grip and conclusion, which is a 1 week continuance. I don't know. Do you think that this next hearing occurs? Do you think she has the good sense to just be done with it? Or is she going to come back and say the same stupid crap next week? I think it's B. I think it's B. At which point the judge needs to back up what he said and say, okay, fine, there are issues. Get out of my court. I think that's what needs to happen. And I wouldn't have known that, but thanks for everybody who was like looking ahead, and they just said, "Oh, keep going. The next, I'm doing this," and in the background, I'm getting messages, and they're like, "Oh no, the next two Karens, you want to see them too?" And then she comes back. I'm like, "Oh, perfect. We'll just ride this right through." Thank y'all for coming out. I appreciate it. I'll see you soon.